Dear students, let us start today's newspaper, that is 28th April 2016. The first article is related to the small states versus large states argument, and also how the small states gets affected due to central hegemony, how the federal balance is shifting in smaller states. Let us try to understand this article. Before going into this, in a democratic country, especially in India, the citizens are sovereigns. So these citizens, they are delegating their authority to the representatives. And representatives, what the authority they enjoy is a derivative authority. In this context, they have to work towards the best interests of the citizens. The second is, if these people, they are going beyond the view or else aspirations of the citizens, there shall be mechanisms to show them the door. So in this context, the democratic decentralization is discussed. We have 3 new states created in 2000 and latest is the Telangana. How the democracy is functioning in these particular states, if we examine, most of the cases in all these 3 states, that is Jharkhand, Uttarakhand and Chhattisgarh, new states are created on the demands of the justice, which has led to the popular movements. Once the states are created, the elite has captured the power. In this case, the stability has decreased, and Jharkhand, if you observe, it's in a perennial state of instability. And the federal balance also shifted more in favorable towards the center. And center is able to use the Article 356 for its own benefit. And the conditions of the tribal people and the scheduled castes over here got worsened. So in this context, the primary demand which has led to the creation of the smaller states was not met, but identity politics dominated by the elitist sections of the society have led to the further deprivation. So that is the centrality discussion. Now, National Court of Appeal. So we know the access to justice in a democracy is a basic right, and it is essential for the rule of law, which is mentioned in Article 14 of the Constitution. So in this case, the access to justice, there are 2 major hindrances in India. One is related to the geographical factors and pending of the cases. So if you take the T.S. Thakur's argument, the Chief Justice of India's argument, what he said is the number of pending cases are increasing in India, and there is no proportional rise in the judges. The Supreme Court is supposed to function as a constitutional court, and every bench which has to look into the constitutional matter shall have minimum of 5 judges. But most of the constitutional cases are looked by the 2 judges due to lack of sufficient numbers over here. And the second thing is, the accumulation of the cases, it is slowly increasing, and from 1960 to today, the number of constitutional cases have attained from 100. Today they are less than 8 in a year. So in these circumstances, the Supreme Court has to function more as a constitutional court, and other functions which are coming as appeals, which is more a routine work, shall be devolved to a National Court of Appeal, which has to be created for this purpose. This is what is being suggested. And the second thing is, the geographical location of the Supreme Court is inherently disadvantaged for the southern states to appeal in Supreme Court. It is clearly visible in the statistical data. Most of the cases that are coming to Supreme Court, they are majorly from Delhi High Court, followed by Punjab and Haryana, followed by Uttarakhand High Court. Lowest is from the Tamil Nadu High Court. So, appointment of the regional benches is suggested by the Law Commission in its 229th report. So, we have to take this step forward because it do not need any constitutional amendment. So, the Chief Justice of India, in consultation with the President of India, can create the regional benches. But however, the major objection of the Supreme Court and also the central government is it will disturb the unitary pattern in which the Supreme Court is functioning, and it also gets swayed by the local influences. So this is what is the objection it is talking about. So now, If you see the United States during the Roosevelt era, when he tried to tinker with the independence of judiciary, then the alibi which he has used is the huge pending cases in the judicial cases. So in this context, the National Court of Appeal has to be given a serious consideration with regard to solving the issue of pending cases. Now coming to the generic medicines. Now let us see the situational analysis in India. We have out-of-pocket expenditure which is more than 50% in India. Though among the insured people, though few people have the insurance, most of the expenditure these people make, that also belongs to this thing. So it means most of the expenditure, even for the insured and uninsured, is out of pocket. The reason is the cost of the medicines. The medicines are of two types. For example, if you take a composition, Dr. Reddy's can manufacture the same drug or some other company can manufacture that. So the Dr. Reddy's may have the patents which is expired, then the generics can come up on the same drug. If Dr. Reddy's drug costs around 20 rupees, generic will cost around 1 rupee. So if doctor, instead of prescribing Dr. Reddy's branded drug, if he prescribes the composition or if he prescribes the generic drug, that is going to decrease the out-of-pocket expenditure for an ordinary individual. In this context, the government has established the Jan Aushadhi shops. The problem with the Jan Aushadhi shops is it is selling only generic drugs, but other drugs the patient has to go to the other places, and awareness is totally absent among the patients with regard to these price differences, and the lack of prescription of the same drug and people's willingness to adhere to the same drug, that also is discouraging the Jan Aushadhis. And added to that, the progress on the establishment of the Jan Aushadhi shops is also very tardy. So these problems have to be rectified to improve the affordability to the access to medicine in India. And coming to the European Union, there are certain systemic challenges European Union is facing. The first one is social integration did not finish. So more than the social integration, the economic integration was given due priority. Across the Europe, always the problem is the social integration. That's why world wars always started in the Europe. So every country believes that it is supreme to the other. So obviously it's a sovereign nation, but however, understand when you are coming into a committee of nations, certain compromises have to be made. People have to give and take among these compromises. But on many social issues, they don't have a common understanding, especially with regard to the accommodation of workforce and immigration across the countries. And coming to the economic union, there is a common currency and common monetary policy developed, but it did not lead to the fiscal union. So because of this imbalance, it has led to 2008 crisis. Some countries have led to the fiscal expansion irresponsibly, and that has pulled the entire European Union into crisis situation. And the next is, the new growth centers are located in Asia and Africa, but European Union still focuses towards America. So it is too Atlantic focused without significant attention to the growth centers of the world. These three need to be rectified for European Union. Coming to Make in India, now we need to understand what is Special 301. According to this, US Trade Representative will classify a particular country which is having the laws or legal framework which is against to the business interests of the United States companies. So based on that, it will classify the countries into three categories. In this, India was kept in the priority watch list. So what it says is the intellectual property regime in India is not very favorable towards the protection of the American interests or multinational companies and their products which will be launched in India. So the major complaint is about compulsory licensing with regard to the drugs are concerned. As for the Pharmaceutical Act of India, if any drug is excessively priced and is not available for public health needs, the government can allow the production of the drug by the other company, though it is patented. So here, many of the multinational companies are leading to evergreening of the patents. What they do is they launch the product with some compound and they tweak the compound a bit and they apply for the patent again. So this concept is called evergreening of the patents. The Supreme Court has clearly said in Gleevac case that evergreening of patents shall not be allowed for. So that has a bolt, or else that is a big draw punishment towards the Novartis. So in this context, this compulsory licensing provision in India is closely observed by the United States of America. Now, coming to the Sex Offenders Registry, we all know that CCTNS, that is Crime and Criminal Tracking Network Systems, it is being developed by the Home Ministry. So in this, the repeated sex offenders and all their details, including DNA, even the data related to the minors will be placed in this particular database. So this is going to help as a tracking mechanism of these offenders. Now coming to the authority of the speaker. This year on the authorities of the speaker, there will be a question. Anti-defection law, authority of speaker, some question has to be there on these matters. The Supreme Court has said, now let us see the background of this. Now, money bill was introduced in the Uttarakhand assembly, that is the finance bill. Then speaker said it was passed. Then the central government said the speaker did not take the voting on to that and then passed the bill. So, what is the right of the central government to question the authority of the speaker is the first thing. Now, if you see, in the Telangana creation, Andhra Pradesh Reorganization Act, the parliament itself has passed the bill through voice vote. So, the speaker's authority in the house is final and cannot be questioned. So, in this case, who is questioning or who is the authority that can question the speaker's house? This is the fundamental question which is raised by the Supreme Court with regard to the ongoing Uttarakhand crisis. Let's come to the Indian Express newspaper. Now, a comparative index was developed across various states in the country by Bengaluru-based NGO, that is Public Foundation or People Foundation and People Affairs Center. According to this, they have taken some 10 criteria: accountability, transparency, etc. And based on this 10 criteria, they started ranking various states. So now, most of the southern states have occupied the better ranks compared to the northern states. So, but however, it provides for a relative comparative index from a neutral eye perspective, so which can provide for a necessary barometer for analyzing where the various states stand. Now, coming to the high-speed rail, why India need that? Now, Wuhan to Guangzhou, there is a high-speed rail in China. And similarly, Beijing to Tianjin, there is a high-speed rail in China. What is the experience of China tells us? Now, urbanization has become more balanced. It means it is not a primate city which is being developed. The industries got distributed because there is a better connectivity and human and material resources can be better moved on this particular tracks. And second is the technological know-how. Within the agreement of the Japan, it is clearly stated that there is no regulation that the Japanese have to, or else given the primacy in this particular thing. An entire technology transfer can happen. So we have something to gain on technology. And finally, with regard to the traffic, we have many externalities with the trains. From air and road transport, it has been transferred to the railways, which costs much less to us. So these are the various advantages why we need to promote this. And coming to prohibition. So we all see in India the prohibition from a moral perspective. But however, if you clearly observe, prohibition has to be seen from health perspective. So if you take in the Western countries, United States also has tried prohibition. But however, it has led to the criminalization of the entire society. And the state was unable to implement its will, its law. Because people, when they are addicted to the substances such as this, the poor gets most worst affected because of the alternative sources which they try for, and the government has no proper control over these alternative sources which can affect their health. Huge tragedies in India. And also from producers to consumers, everyone becomes criminalized because of these laws. Instead of that, if it is seen from health perspective, the government has to focus on the de-addiction centers and also various other steps which are more successful. So when government can't implement something, it's better not to implement it. So this is the essence of this. Now let us recapitulate this. EU needs a reality check. The three major problems of EU are lack of social integration, monetary union without fiscal union, and too Atlantic focused. And coming to the governance issues, now with regard to the generic drugs, the major problem with regard in their use is lack of awareness and lack of proper orientation to the doctors, vested interests, and lack of proper regulation. These are the things. With regard to the small states, whenever there are small states, the federal relations are shifting in favor of the center, and added to that, the states are losing the financial and other benefits, and added the bargaining power of the states is decreasing, and instability is the rule. And National Court of Appeal, it provides for the increased access to justice and decreases the number of cases, and it makes the Supreme Court to function as a constitutional court. Now with regard to the Special 301, India is placed under the priority watch list by the United States. It was a previous question. And Offenders Registry, with regard to the sexual offenders, under CCTNS, their clear registry will be maintained. Now Prohibition, it will be more successful if the alcoholism is seen from a health deprivation perspective rather than from the other considerations such as domestic violence or moral perspectives. So these are the things we need to understand in today's paper. Thank you very much.